Before I turn to the subject matter as given in the program, Mr. Curti, on the way out, remembered that he had failed to mention in his speech something that he wanted to, namely that the killing of Serbs at and at the end of the conflict has to be dealt with, and he's happy that I should, in one sentence, simply make the point that he meant to mention it, but it was overlooked, and it will be dealt with. Yesterday, I explained to you that I have been involved as counsel at the specialist chambers. So that's a declaration of interest. And of course, I must also make it quite clear that if you are at a court like that, you have to be approved counsel. Of course, I am an approved counsel, otherwise they wouldn't have me there. And that means I have to show the specialist chambers respect due to a court. You can turn it off for the time being, but thank you very much. I don't want to spoil the thrill. And you may not be able to read it. Stop reading. Don't deny me. That's better. Right, we'll come. I didn't pay it. You're troublesome. So, of course, I have to respect the court in the way that one does, and respect the judges and so on. That does not mean that if I regard it as in the interests of any client I represent, or in the interests of justice, which ranks always above the particular formation and conduct of a court, it isn't both my freedom and my duty to do as much as I can in those particular respects. And I'm sure the court, which is no doubt looking at this, live streamed or otherwise, will understand that. And I will come to it again later. Insofar as I mention anything that emerges from my surprising appearance at this court, I have my client's specific instructions to do so, although I don't envisage or forecast saying very much, if anything, that is not already known in the public domain here in Kosovo. Public domain in Kosovo is very wide, of course. I never write an email. I barely make a phone call without first reminding myself that the essential assumption is it will be leaked in due course, and then always is. Before I turn to the specialist chambers and the few things I want to say about the Marty Report, you will recall yesterday that I was, perhaps you didn't hear the criticism, but I was criticized for being over harsh on lawyers. And it seems to me that I should now be over harsh on someone else. So I'm certainly not going to be over harsh on our Kosovo hosts. I'd rather be broader than that and be over harsh on the entire Balkans. And so that's what I fully intend to do. And let me tell you that from our experience, Nana's and mine, not of course in relation to this country, but in relation to another, if you write long, detailed, helpful opinions and advices on matters of great importance to the president of a country, not this president, another country, on a topic, let's say genocide, of what can you be sure? That he'll never read it. And he certainly won't act on it. And the other thing of which you can be quite sure in authoritarian states, which all the Balkans were, and still are, is that they're very reluctant to take on authority figures. There's a real inbuilt inclination to behave. And I'm afraid Nana and I don't have that inclination. Well, you were late arriving this morning, so Chana said, well, maybe get up a bit earlier. Now to the specialist chambers. You've heard a lot about them. And this is an example, not just of why presidents should read documents, but why everyone should read documents and never do. I mean, Nena had, this is an aside, but it is absolutely stunning. In another part of the Western Balkans, there was a really major concern by a real victim group about documents that had been kept from public view by the Serbs. And these documents were thought to bring resolution to the critical issue of genocide at Srebrenica. And the documents were blacked out, and it was a terrible wickedness on the part of the OTP, of the ICTY, the prosecutor. The documents later became available, and our experience was that nobody read them. Now let me talk to you about the Marty Report, giving you just a little chronology, because I think the subject matter of my talk is the legality and legitimacy of the court, and that requires a reasonably detailed explanation of its history and, as well as, so far as we know anything about it, its present function, to which I will turn before the end of my time. In 2003, there was an investigation into organ harvesting within the ICTY. It was not drawn to my attention, it should have been, but it wasn't. It was dealt with by Mrs. Del Ponte, and the allegation concerned Ramush Haradinaj and others, also his brother Daut. The inquiry led to a finding that there was nothing to be concerned about. There was nothing there. This is the famous yellow house for those who know anything about it. And so in 2004, before Mrs. Del Ponte left the ICTY, the investigation was dropped. It was never expected by those who have an important role to play in the developing story that these documents would come into the public domain. But they did. When they did come to the public domain, all 30 pages of them, and they look entirely legitimate documents from the ICTY, addressees, the people to whom letters were written, had for the most part been cut off. But either by intention or design, one name was left on. And it was Clint. And the only Clint it could be was Clint Williamson. So Clint Williamson knew that there was nothing in it. Why is that important? Who knows? Because Clint Williamson was subsequently in charge of the investigation that led to the creation of the court on the basis of organ harvesting. Forget those documents for the time being. The next thing that happens is Mrs. Del Ponte retired, or came to the end of her mandate, and she wrote a book. And somebody encouraged her to revive the allegation of organ harvesting, which she did. But now Thaci was prime minister and Haradinaj was not. And for absolutely no accountable reason on any evidential material I've ever seen, good gracious me, the person she now alleges to have been involved was Thaci, not Haradinaj. Almost as if it would be satisfactory to pick off a Kosovo leader. Following that, there was the Marty Report to the Council of Europe. And again, this brings me back to the question of the wisdom of reading material. If anybody's interested in forming any view about this, get hold of the Marty Report and read it carefully and line by line to see what it says and what it doesn't say. Because it says almost nothing about evidence. It barely claims evidence existed. It uses curious words, and Senator Marty is fluent in English, uses words like there were indications that this happened and indications that that happened. Is that important? Oh, yes. But before we turn to why it's important, the report itself, as I say, you want to read it and then read it slowly and then read it again and see how the 43 footnotes are not really like proper footnotes where you dig deep into detail. They're just more generalizations dressed up as footnotes. But there's a very interesting passage in some concluding remarks, paragraph 175, which includes this: our task was not to conduct a criminal investigation. We are not empowered to do so. And above all, we lack the necessary resources, let alone to pronounce judgments of guilt or innocence. So this document, whatever it is not even a criminal investigation. Why is that important? Because as Robert said earlier, it is not just to some extent the founding document for this court, it is the document for this court. And again, declaration of interest, I appeared on a couple of occasions, once with Robert and once with the Minister of Justice, at negotiations about the statute and then about the host state agreement. And at the one about the statute, we weren't able to achieve anything because they weren't really negotiations. We were told what was in the statute and that was that. But the one thing that we did achieve was to take the word Marty out of the statute, because we said, surely the history of the statutes of Kosovo don't really want to be subject to a name of an individual. So we referred to the resolution. They agreed to that. But that's without any change to what the source of jurisdiction is. The source of jurisdiction is the Marty Report, which was not a criminal investigation. And accordingly, if people find themselves taken, called, summoned, dragged to The Hague as suspects, and if ever an allegation is put to them, one question that it's quite sensible to ask is, where in the Marty Report do I find an allegation that founds jurisdiction for you to be putting that allegation to me? Because it will probably be a task beyond the ability of the prosecutors. Now, the Marty Report then led to the Clint Williamson investigation, he who already knew that there was nothing in the 2003 investigation, and then to the creation of the court, the imposition of the court. We heard about that earlier today from Mr. Curti, but I think, and I'll be corrected by those who know about these things, who may indeed still be sitting, or maybe members of Parliament here, members of the Assembly here, the pressure applied to have the court created went very far indeed. And unless my recollection of either information or reliable information is wrong, I think an ambassador, namely the American ambassador, rang every Assembly member to require them to vote in favor of the court. That is the court that is facing Kosovo now. And if I'm wrong about that, I'm sure somebody will correct me. And look at the period of time that has passed between the alleged offenses, if there are ever any, in 1999-2000, when UNMIK was there gathering material, and now. And as the ombudsman or person made quite clear yesterday, in the absence of additional material evidence of a significant kind, that's my gloss on what he said, coming since 1999 to an authority, it's hard to see how anybody charged in respect to that earlier material could be said to be enjoying a trial compliant with human rights. So these are amongst the issues that it is necessary to raise in challenge to the legitimacy of this court. And I'll give you another example drawn from my experience now of just how careful practitioners in this country and elsewhere should be about this court. Hands up, please, Albanian lawyers, Kosovo lawyers. Any? 1, 2, 3, 4, 5, 6. Does any of you know what an agreement on statement of limited use is? In one of the cases where I was acting, it's a great experience. I've never been the duty solicitor in the police station sitting by somebody being interviewed for alleged crime. It was a very interesting experience because you're sitting there trying to find out what the coppers have got on the guy you're representing. And of course, in civilized and developed countries, what happens is that the policeman gives the lawyer a summary in advance so that at least the lawyer and the client, the person being interviewed, can know something about what they've got to prepare for. That doesn't happen, I can tell you, in the specialist chamber. Not one word of what you're going to face is explained to you. I don't know how you're supposed to turn up to face an allegation that's 20 years ago without any warning of what it's about, without any notice of what documents you might want to turn to. It might be thought to be absurd, but never mind. At one of these interviews where, as with all of them, the right to silence was, in ones in which I was involved, the right to silence was being exercised, a document was thrust across the table, a document, an agreement on statement of limited use. I had no idea what it was. Time was taken to explore what it was, and I eventually remembered that these had, or something similar to this, had been used at the ICTY when I was prosecuting, and as soon as I heard about them, I ruled them to be unusable because they were so corrupting of process, but they were similar to this. But the document that was proposed put, as it was or could have been, to a Kosovo Albanian lawyer and a Kosovo Albanian suspect, would offer him the opportunity to speak freely and honestly on the basis that anything he said would not be used against him. But, and this was never made clear, if having, make it practical. Supposing in an interview you say, okay, Sergeant, or whatever it is, policeman, I confess I killed Mr. Smith on the railway line in June. Now, they can't use that against you if you are tried for the murder of Mr. Smith on the railway line in June, but they can go out and get all the other evidence of which they were otherwise unaware to prove that you were there at the railway line and convict you. Now, do you not think that might be something that should be explained to unknowing lawyers and unknowing defendants? No. And I've written to them and said, don't you think if you're going to start using this type of document, which is an American document, any American lawyers here? I think it's, yes? Was that a sort of gentle hand up? Do you know about these documents?
That's collected from a statement that would otherwise not be admissible in court, if this explanation helps.
Thank you. Yes, it does to a degree. I mean, obviously, I looked it up when I read about this thing, and I think they're probably used in insurance fraud cases, something like that, but that's about all I know. So I suggested to their prosecutors that they should, if they're going to use these things, they should explain exactly what the risks are for the suspect, they should explain what source of law they're going to go to. American law, because that's, I think, the only place where these things are dealt with. Because it is said that whether you've told the truth or not is entirely for the prosecutor to decide. And if the prosecutor decides you haven't, then everything in the interview goes in and becomes admissible. Extraordinary, in my view. And as you may know from the press, and because I gather other people beyond those limited numbers for whom I've had an interest have indeed spoken to the press, the suspicion is abroad that what's happening at the court at the moment is that people are being taken there as suspects, basically in order to get evidence. It is obvious, isn't it, that if that happened, it would be an improper use of the court's processes. And there's a phrase from the general law applying to conflict that applies here. Although lawyers in big offices are unlikely to turn to it immediately, there is no defense of superior orders. If you as a lawyer in an office are instructed to do something that you know is wrong, you don't do it. And so if there is, it's all just surmise because we know very little about the court, if there is a policy or practice whereby people are being taken as suspects in order to get evidence from them, then all the lawyers engaged must know that that is wrong. That's about, I think, all I need say to explain why this court's legitimacy must be considered and challenged hard. This is separate from the political reasons why the court may or may not have a life to come. The issues that have emerged from consideration of the Marty Report, Clint Williamson's obvious knowledge, and all those other things are things that I can mention without knowing them to be true, because I don't know them. They're only as things seem. It may well be that the specialist chambers will, when they do their work in public, be seen to be squeaky clean, and there's an explanation for everything that looks unusual or odd. But if things look unusual or odd, then they should be tested and examined. And that brings me to my last point, which arises from, I think, Robert's or maybe Giulietta's contribution, and that is was in answer to a question about narrative, and whether the narrative is being, a narrative is being written that is incorrect. And we overlook why it has been so easy, if it's the case, for Serbia to write incorrect narratives about, for example, Bosnia, as well as about Kosovo. And the reason is that there is no public right of access to documents. This may be less important in the case of the KLA as it happens, because there may be less or almost no documents of record there. But in relation to the other parties, Serbia in particular, as well as the international community where they play a part, there is no doubt that documents exist that would show a better and ultimately a correct or true, if you want to use the word true, narrative of what has happened. And those documents are not available to you or me. Or when we appeared, even for the prosecution, in the ICTY, even for the prosecution, because that particular court was so structured as to give to Serbia the same rights of withholding documents until absolutely forced to release them as America or Germany or the United Kingdom. And I'll end on this, there was one document that we eventually got, courtesy of a decision by the court, ordering a document to be produced overnight. And that document included, in respect of Kosovo, the phrase village cleansed. And it was, in the words of Stephen Kay, who was representing the other side in post-counsel, as I recall, on an escalator going up an underground railway station in London, his terminology, not mine because I never use it, he said, that's the smoking gun. That category of document had been sought by us under the rules of the court for 4 years, Nana? 4 years. It's the single document that makes that confession. It's the sort of document that gives an accurate record, and it's the sort of document that it serves those who create courts, such as these, to make unavailable. Oh, thank you so much. Let's have that one question. I got carried away, didn't I? And I forgot. It is, there is a document, there are actually more than one document, but thank you for reminding me, Nana. Is it coming on now? Right. It's always been interesting to see how organ harvesting, that is killing people to order, ripping out their organs and selling them on the black market, has been the starting point and probably the allegation without which there would never have been a specialist chamber. And yet, the allegation, which always looks like the sort of thing you say in war, has actually been said against other people before, and what's more, in the order of the conflicts, because this document, which comes from 2011, from the Republic of Serbia and Krajine's government in exile, and is an announcement that before the Albanians, Croats, and Bosnian Muslims harvested organs of Serbs and Gypsies too, the government and the parliament of the Republic of Serbia and Krajina sent, along with this announcement, a rebuke to Serbia's media because since 2005, in Serbia, articles of the government of the Republic of Serbia and Krajina are censored, serious violation of the national and state's interest. New paragraph. According to a report of Dick Marty, a member of the Parliamentary Assembly of the Council of Europe, Albanian separatists, allies of the EU, murdered Serbs and Gypsies and harvested their organs from their bodies. These organs were sold to clinics throughout the world. Dick Marty, who is a very moral man, cooperated with the authorities of the Republic of Srpska, which gave him evidence about the Croatian and Bosnian Muslim soldiers who, in order to sell organs to clinics throughout the world, murdered Serbs and Gypsies at Bosanski Brod in 1992. These crimes were very horrible. Even young children were victims of that organ trafficking. The Serbian and Gypsies civilians, including children, were placed in buses of the Croatian and Bosnian Muslim army. These people were brought to Sjekovac, Bosanska Dubica, and to an unknown place in Croatia where, next page, they were murdered and their organs were removed. Their organs were transported by a white helicopter to the airport in Slavonski Brod, Croatia, and so on. So the allegations which found this very controversial specialist chamber are only the same as the allegations made in respect of Croatia and Bosnia in turn. No specialist chambers there.
Thank you, Geoffrey.